Welcome back. This is Kay from KISS Migration. Today we will explore the statutory interpretation of the Lonely Canadian provision. This video tutorial consists of 3 parts: statutory law, common law, and commentary. Let's begin. The grammatical reading of Section 117, subsection 1 of the Immigration and Refugee Protection Regulations will make sense to you. The different members of the family class can be found in paragraphs A to H. Spouse or partner, child, parent, grandparent, orphan, to be adopted child, and other relative. We will focus on paragraph H, other relative. Per section 2 of IRPR, a relative is a person who is related to the sponsor, either by blood or adoption. The traditional interpretation allows lonely Canadians and permanent residents to sponsor their last remaining relative if they do not have a spouse, partner, child, parent, sibling, niece, nephew, grandparent, uncle or aunt who is a Canadian citizen, Indian, or permanent resident, or who they may otherwise sponsor as a member of the family class. Let's have a quick look at a generic family tree to understand the formulation of the opening words regarding the relationships. For example, a relative who is a child of the mother or father. We're starting at the person who is the sponsor. So we start at the bottom, mother or father, which means we're going back a generation to the parents. So a relative who is a child of the mother or father, which leads us to brothers and sisters, so siblings. Next concept, a relative who is a child of that mother or father. So again, we start at the sponsor, go to the mother or father, which are the parents, and then the child of the child, which equals nephew and nieces, or commonly referred to as nibblings. A mother or father is simple the grandparents. And a relative who is a child of the mother or father of that mother or father. So if we start here, sponsor, mother or father of that mother or father, going to the child, equals uncle and aunts. Simple. Moving on to the common law interpretation. First, you have to be able to find it. You can use free of charge CanLII to find the SENVA decisions. So you'll type in SENVA as the case name, and you can see a listing here already. FC stands for Federal Court from 2016, which is considered SENVA 1. And then SENVA 2018 FC is SENVA 2, and there are 2 decisions on that. One is discussing the certified question so that the parties can appeal to the Federal Court of Appeal. Here you find the decisions from the Immigration Refugee Board in 2015 that led to SENVA 1, and then 2016 that led to SENVA 2. And most importantly, the Federal Court of Appeal decision from 2019, which we'll discuss shortly. So it basically all started with SENVA 1. So if you click on that, you will be able to read the decision that created legal uncertainty for about 4 years. Beautiful summary can be found in the Federal Court of Appeal decision. The main points of interest are paragraphs 19 to 21. So just scroll down until you see on the left hand side paragraph numbers 19. In SENVA 1, the Federal Court found that the historical interpretation was too restrictive and created a split in case law in 2016. The main interpretation issue was the definition of the wording "may otherwise sponsor," found in section 117, subsection 1, paragraph H, subparagraph II of ERP. Yet, the Federal Court of Appeal stated in Bouzele that the provision is clear. One must only determine whether any listed relative exists. To exist means to be or to live, or even to be alive. Under paragraph 21, the court stated that the formulation "may otherwise sponsor" does not expand the operation of the provision to permit a sponsor with closely related family members to sponsor one distant relative regardless of age. Hence, the FCA concluded that the conventional interpretation is right and Senva 1 is wrong. If you want to have a look at the background of what's going on at the federal courts, you can investigate on their websites and go under Court Files, put in both courts, meaning Federal Court and Federal Court of Appeal, type in Senva and then click on Submit. And the first one here is the FCA decision. You'll click on the Read button, and there you can see the entire process of the case. So important to us is to find when it was decided, which was December 17th here. The judgment was dated December 17, 2019, and the reasons for judgment were rendered same day, but then there was an amendment made on January 13th. Amended reasons for judgment rendered on January 13th, 2020. So basically, on December 17, 2019, a panel of 3 Federal Court of Appeal judges unanimously dismissed the appeal with cause. However, the decision was amended to appeal dismissed without cause on January 13, 2020. If you would like to learn more, I invite you to read my articles on the interpretation of sponsoring a relative at my consultant. Simply click on the links in the description below the video.